So we've all been there, stuck outside of our car or our front door, maybe even our office building, and we simply can't make it inside because we're locked out. However, imagine this same situation, except it's not your car, it's not your house, it's not your office building, it's your rent house, and your tenants have said, nope, I took it on my own and switched out the locks, never telling you. Talking all about changing locks and what you can do and what you absolutely should do in response. Let's get started. So I've been doing this for a long time, and it never ceases to amaze me how little many landlords know about their own leases and the rights they have to enter their own property. Many times I've had conversations with landlords and they're shocked at what the law says and what their lease says about their right to enter property. It kind of takes someone who has done it 1,000 times to open the door and say, look, this is what it takes and this is what it means to own residential property and to manage it in a way that makes sense. And so if you're unfamiliar with what your lease or what the laws in your jurisdiction say about your right to enter onto real property, you're going to want to stop and make sure you get your head around what the law says and what your lease already says about your rights to enter, because these rights are crucial. Does your lease or does your jurisdiction require that you give some kind of written notice before you enter? Does it allow you to enter with another party? Does it require that if you are not there, that the party entering have some sort of special permission? Can your handyman simply enter the property unannounced? Now, these are important facts that you need to get clear. In the state of Texas, 3 basic things are required of a landlord who means to enter real property that's occupied by a tenant. First, there has to be a reasonable basis for the landlord to be there. Second, the entry has to be at a reasonable time. And finally, the third requirement is that the landlord enter in a peaceful manner. So whether you are conducting an inspection of the property, or you are performing a repair, or perhaps you're showing the property to prospective tenants because you're at the end or near the end of the current lease, these are all generally seen as a reasonable basis to enter the property. The next issue is whether the timing is reasonable. If you're showing up at 4 in the morning, probably not. But generally speaking, if you're there during normal business hours, 9 to 5 is a good rule of thumb. If you're there during normal business hours, you can presume reasonability. Now, that might not always be the case, but make sure that specific to your case, the time that you mean to enter is reasonable. Part of what makes that time reasonable is the notice that you send. Now, in Texas, notice is not an absolute requirement. Some leases do require it. If your lease is silent on the issue of notice, I would still recommend that you send a notice. Now, this is not the same as asking for additional permission. State law and your lease probably already give you adequate permission to enter for any one of these reasonable reasons. But you might want to give notice to your tenant because it's possible that although the time that you select on its face appears reasonable, there may be extenuating factors that make it unreasonable. By giving notice to your tenant, you can kind of get ahead of this and find out, not do I have your permission to enter, but do you understand that I'm coming in on this date and at this time. If that ends up being a problem for the tenant, they have an opportunity to inform you of that problem. And if it's something that can otherwise be rescheduled or can otherwise be planned around, then both of you will be better off for it. Now, the issue of entering in a peaceful manner can be complicated, especially if the landlord enters peacefully, but the tenant breaks that peace. Believe it or not, if a tenant breaks the peace, the landlord at that point no longer has that peaceful entry and may not at that point enter the premises. So certainly if a landlord comes yelling and screaming and having a shouting match with their tenant about their right to enter, by that behavior, the landlord has just disqualified himself from that same right. The entry has to be peaceful on both sides so that the landlord can enter safely at a reasonable time for a reasonable purpose. So why is it so important for a landlord to establish this as a necessary part of their property management? Well, the key is what happens if there is some sort of emergency, or if the tenant makes a repair claim but can never make the property available to you. You want to make sure that you're able to repair the property, not just because it's a request of your tenant, but because you don't want some small issue to become a much bigger issue. You also want to inspect regularly, number one, because your tenant may be harming your property, but mainly because your tenant may simply miss a problem that's occurring on the property, either because they haven't noticed it or don't know to look, or have simply overlooked it. And you want to be on the property to make sure that if you see something that has gone wrong, that you can address it quickly. You don't want to just wait until the end of the tenancy, because by then what might have been a small $100 problem has turned into a large thousands of dollars of problem. All of it preventable with a routine inspection. So you want to make it clear to your tenant that not only that you have this right, but that you will be exercising the right to enter the property, and that changing the locks is not an acceptable response from your tenant. Now, how would you respond if in fact you showed up for one of your routine inspections or in response to a repair request and you find that the lock has in fact been changed? Well, one very necessary response would be to inform the tenant that they are in breach. I strongly suggest that each time you inform your tenant of a breach of the lease, that you do so in written format. You always want to issue a written notice of lease violation and then give the tenant an opportunity to cure that violation. Perhaps they changed out the locks and kept all the hardware. Well, while you're there, you can ask them to replace it, or you can reinstall the original hardware and hand back the current hardware that's in the door and inform the tenant that this is not allowed and that it in fact is a violation of the lease for them not to do it again. Now, you may be thinking, well, the moment I leave, they're just going to swap it back out and prohibit me from doing it. Well, that may or may not be the case. If it does repeat itself, then you should repeat your notice and issue notice every time they violate the lease. Ultimately, if they're violating over and over and over again, even if it's the same violation, that might serve as a basis for eviction, even if the tenant is paying their rent. If they are prohibited from changing that lock, you have the right to say, no, I want the original lock back. Now, let's say not only did they swap out the lock, the original hardware is gone. Well, now you're going to incur costs. And so along with changing out their lock and getting your lock in place, you're going to bill them for your time and you're going to bill them for the costs of that lock replacement. Your lease should explicitly prohibit changing the lock, and your response should be one, in writing, notice of lease violation, and then in writing, notice of the costs to repair the property back to its original condition, or the costs to install a new lock, and now a reasonable amount of time for the tenant to pay those costs to you. So what if a tenant, in response to a notice that you give them of your intent to enter the property, says, let me stop you right there. No reason for you to come. I'm not going to let you through the front door. Don't come. Well, just like coming upon a home where the locks have been changed, if for whatever reason, change the locks or simply barring the door, the tenant will not allow you to enter, you should respond again in writing with a notice of lease violation. That notice should inform that tenant of the section in your lease where you are allowed to enter. And if there's a section in the lease, and there really should be, that prohibits them from excluding you from reasonable access to the property, you want to point these provisions in the lease out to your tenant and say, I do intend to be there. If you prohibit me from coming, I will issue a notice to vacate. If this repeats itself, unfortunately, I will have to issue a notice to vacate and proceed with an eviction filing. And so you may have a tenant who either A, stubbornly says, no, I don't care what the lease says, you're not coming in. You should, and this is, again, not a legal requirement in most states, simply my suggestion. I would suggest a 3 strikes before they're out policy. If you run to the court with an eviction simply with one instance of the tenant preventing you from going in, I don't know that that's going to be as strong as if you go with multiple instances of it that are accompanied by written notices for each event. And so perhaps you want to get in during a particular month, and at the beginning of the month, in the middle of the month, and at the end of the month, you have sent notice, they've prevented you from going in, and you've issued notices of violation for each instance. Then I think in the following month it would be appropriate for you to send a notice to vacate for the repeated violations of the lease. Again, one time may not be enough for the judge where you're presenting your case, but multiple instances of lease violation, even when your tenant is paying rent, can serve as a valid basis for an eviction. If you're going to ask yourself, when is the best time to bring this issue up? I tell landlords this always. The best time to bring this up is not moments before you need to enter. It actually goes all the way back to the lease signing. Before you sign that lease, before you accept any funds from the tenant, before you hand over those keys, you're having a conversation with them in which you are explaining, among other things, your right to enter and your intent to enter to inspect. My recommendation is that you're there after the 3rd month and after the 9th month, that you inspect the premises once they're moved in to make sure that everything's going well. You might, for example, say the lease begins on date X. I will be there on date Y, which is at least 3 months after you've been in possession. I want to make sure everything's working well. And the tenant may respond and say, no need, I run a tight ship. If anything's wrong, I'll let you know. At which you'll respond and say, well, I appreciate that. In fact, I expect that out of each of my tenants. However, I will still be on the property to make sure myself of the condition of the property. And so let's schedule that date now. Because by mentioning it early, not only does the tenant now come to expect that you will be there at least twice during the 12 months of that tenancy, but if they are vehemently against it, they will voice that opinion there. And maybe you'll have a difficult conversation with them in which they say, look, if that's the case, I don't want to sign the lease. You should take that conversation seriously, because if it is that strong of an opinion, you'll want to say, well then, I'm going to pull back this contract, I'm going to pull back these keys, and we'll look for the next qualified applicant, because this is a big deal. You're going to want to make sure that you can maintain your property on your terms, that you can care for your property on your terms, and you're not putting everything in the hands of the tenant. By ceding over that control, you're going to lose power, you're going to lose leverage, and generally speaking, you're going to lose money. So managing residential real estate can be complicated, but it's not impossible to do, and it's not impossible to do it well. As long as you have a bright line set of expectations for your tenant, things can go quite well, specifically as they pertain to the locks on your rental premises. You want those locks to stay in place. You want to make sure you always have access, whether for an emergency or for a routine visit, that you always have access to the premises. If you enjoyed today's video, I ask for a like. If you got a comment or a question for me, add that down below. And if you're not yet a subscriber, I would appreciate you considering being our next subscriber. If you are interested in learning more about property management and the kinds of things that will make you a better landlord, feel free to browse through the numerous videos in our library. YouTube seems to think that this video right here is the next best thing for you. I invite you to check that out. And until next time, landlords, happy leasing.